Hello and good afternoon, everybody. My name is Stratos Pahis, and I have the privilege of moderating this panel on reassessing sovereign bankruptcy in a time of global economic crisis. We are so fortunate to have an all-star group of panelists. In the world of sovereign debt, they need no introduction, but I will nevertheless take a brief moment to introduce each of them. Before I do, a very quick note to the audience. We're going to try to reserve some time at the end of the panel discussion for a Q&A. If you have questions that come up before then, questions or comments, please feel free to type them into the chat. Additionally, we invite everybody to come to the follow-up continuing the conversation session to engage further with some of the panelists, their schedules permitting, of course. Okay, so on the panel, which needs no introduction, but which I will nevertheless introduce, we are so lucky to have Lee Buchheit, aptly called a lawyer statesman and the crisis veteran of sovereign debt by the Financial Times. Lee has represented nearly every country that's gone bankrupt since the 1980s. Lee was a partner at Cleary Gottlieb for 43 years, has written over 40 books and articles on sovereign debt, and now teaches at the University of Miami. From academia, we are so lucky to have Anna Gelpern. Anna is the Anne Fleming Research Professor at Georgetown Law School, Senior Fellow at Peterson Institute for International Economics, and co-director of the Sovereign Debt Forum. She is co-author of a leading textbook on international financial law, has written dozens of articles on sovereign debt and international finance, and is widely recognized as one of the world's leading sovereign debt scholars. From both the trenches of government and the financial sectors, we are so lucky to have Daniel Marks. As former Secretary of Finance for Argentina and former chief debt negotiator for Argentina in the early 2000s, Daniel was in charge of negotiating what at the time the world's largest debt restructuring. Daniel is now executive director of Quantum Finances, a financial boutique located in Buenos Aires. And last but not least, from the international legal practice, we are so lucky to have Andrea Menaker. As partner in White & Case's London office, Andrea has represented both states and investors in several groundbreaking international arbitrations. Most relevant for today's discussion, Andrea helped pioneer the use of international investment arbitration as a means for enforcing states' sovereign debt commitments when she represented tens of thousands of Italian creditors in investment arbitration against Argentina. So let's jump right in. The title of this panel is Reassessing Sovereign Bankruptcy in a Time of Economic Crisis. We all know that the coronavirus pandemic has led to a huge economic shock, around the globe. And at the start of this crisis, there was serious concern among international financial experts that it would lead to a new wave of sovereign debt crises. Lee, just to start with you, you wrote a piece about a year ago with a number of colleagues calling for emergency relief for emerging market economies. Can you update us on the state of sovereign debt distress around the world, including the emergency measures that have been taken to forestall sovereign debt crises?
Sure. The pandemic has greatly aggravated sovereign debt problems in many countries. As we entered 2020, debt stocks for many countries, both developing and developed, were at all-time highs. Many of those countries have had to borrow to deal with the effects of the pandemic. In the spring of last year, when the pandemic first hit, there was a great concern on the part of the official sector that a number of developing countries would be forced to face a situation in which they used their scarce foreign exchange reserves either to continue to pay their external debt or to ameliorate the effects of the pandemic. And that seemed an odious choice to put these countries in. Accordingly, the G20 last April came out with something that they called the Debt Service Suspension Initiative, applicable to the world's poorest countries, 73 of the poorest countries. What it proposed was that bilateral creditors, government creditors, would suspend debt service would defer debt service due for the balance of 2020. It's now been extended into the first half of 2021 for a relatively short period of time, 4 years, in order to give these countries some breathing room. The G20 called upon private sector creditors to provide similar debt relief, but that debt relief from the private sector never materialized. The latest development was last November when the G20 again came out with an announcement saying that those countries who are going to exit the pandemic with unsustainable debt burdens, as assessed by the IMF, may restructure their debts under what they're calling a common framework. Essentially, it is the Paris Club process, the OECD creditor countries process, plus China. But that plus China is a big element in a world in which China is the largest bilateral lender. 3 countries have thus far announced that they are going to need to restructure their debt. There will be others as 2021 unfolds. I'll stop there, Strato.
Excellent. Thanks so much. And so it sounds like to me that you're saying the emergency measures have been sort of partial and incomplete. How bad do we expect the crisis to get, given the steps we've taken so far, and assuming there aren't further steps taken?
Well, I'm afraid I can't give you a clear answer. Part of it is going to depend on how quickly the pandemic can abate in developing countries, and that's in part going to depend on how quickly the vaccine will roll out. And then, of course, you have the issues of interest rates. Are interest rates going to begin to creep up if particularly Mr. Biden's stimulus package kindles some inflation in this country? And of course, what will commodity prices be? The hope is commodity prices will receive a boost because there should be a post-COVID pickup in demand, a lot of pent-up demand in the second half of this year. So it's a little unclear how quickly it will all return to normalcy. But the important point, I think, is that most of these countries are carrying external debt stocks now that are significantly higher than what they were before the pandemic. To give you some idea, last spring, at the same time that the G20 was pushing its initiatives, the IMF opened up some rapid financing facilities with little or no conditionality for the members. Roughly 100 countries signed up for that. Now, that's more than half the membership of the IMF. So that gives you some idea of the absorptive capacity of these countries for resources, whether coming from new lending or from debt relief on existing liabilities.
Excellent, thank you. And how does, if you give us a general sense of how the external debt breaks down, obviously, generally, each country is going to have its own circumstances, but how much could be worked out through the common framework, the Paris Club, and plus China, versus how much is left to individual bondholders?
Yeah, because the common framework and the debt service suspension initiative focus on the poorest countries, 73 of the poorest countries, those countries have debt stocks where multilateral and bilateral debt predominates. The private sector is there, but it is not the dominant portion. If you look at the next layer of countries, what the World Bank calls middle income, that's where private sector lenders tend to predominate, and that's where private sector lenders, if they were to refrain from providing debt relief, that would be a great loss. By the way, one difference is that when the G20 came out with the common framework, while they had acquiesced in the private sector escaping and evading providing debt relief in the debt service suspension initiative in the common framework, that is the one that looks forward to full-scale debt restructurings for those countries with unsustainable debt stocks, the G20 said for this initiative, private sector creditors will be expected to provide comparable treatment. They did not confide exactly how the private sector is to be induced to do that, but that will be their policy.
Excellent. Maybe this is a good time to bring in Anna into the conversation, talk a little bit more about the legal architecture that underpins that will underpin some of these workouts with private creditors. You've written extensively about the legal architecture of sovereign debt more generally. Can you give us just a general overview of how these workouts with private creditors would be governed?
Well, thank you, Stratos, and it's wonderful to be here with this terrific group. I would love to also hear Daniel's thoughts on kind of the economic prospects, which, as Lee said, are incredibly murky and depend on a lot of things that we don't normally factor into economic projections. So the whether and the how much are sort of they're distinct questions from the how, right? And the how is going to be a lot more complicated now. And the reason is the following. In the 1990s, the storyline was we used to have banks. By the end of the 1990s, all of the bank loans become bonds. There are lots of bondholders. Bondholders aren't relational. Therefore, they're going to be creditor collective action problems. It turned out actually as partly because of some structural features of the bond markets, but also because of the contractual innovations that have been imported into bond contracts, that bond restructurings have gone increasingly smoothly, notwithstanding some high-profile crises in the early 21st century. What we're going to have now is an incredible diversity of creditors, and bondholders are going to be the least of our problems. So, in Zambia, right, you have bonds and debt to various Chinese lenders, roughly the same amounts, right? And then you have debt to Glencore, a commodities firm that is not part of kind of any established debt renegotiation forum. Then you have the multilaterals and the Paris Club bilaterals, right? So, and increasingly we're going to see this kind of heterogeneity. Plus within the bondholder universe, as we saw in Argentina and Ecuador last year, there are there are increasingly divergent interests as well and divergent strategies. So I think the kinds of creditor coordination problems that we were worried about in the 90s are going to be, we'll only dream of them going forward, I think. Now, on the bright side, I think that this is going to force some architectural reforms, but I'm not sure that these are going to happen without a whole lot of pain and suffering.
So I'd also like to get Daniel's take in perspective on the economic situation and what you foresee, particularly from your from the perspective in South America and Argentina, what you foresee in the next few years. Oh, I think you're muted. Yeah.
Yeah. Sorry. I'm back. I'm here. Thank you. Now, to begin with, as was mentioned, the different categories of countries. Argentina belongs to the middle income one, and therefore has a vast array of creditors. But just also, we have to bear in mind that Argentina has had problems, and even recurring problems with its indebtedness before even the pandemic hit. And the announcement of Argentina going ahead with the restructuring of its own indebtedness was previous to the pandemic as well. So I think one element that now, 1 year after the pandemic hit and almost 9 months after Argentina did restructure its debt with its private sector creditors, uh, mainly bondholders, we have to draw some lessons again. First of all, I think when you do a debt restructuring, it has to be put within a context. That context being who's in charge, what's the political mandate, and what the economic policy looks like. And in fact, what we've seen here is Argentina altering a bit what was the usual sequence of events. We did have a political change. It was unclear from my point of view that there was a big change in direction in a way that would reassure all of the constituencies, creditors included, but also investors, workers, and even inhabitants, that Argentina has overcome its recurring problems. And therefore, we in Argentina obtained a debt restructuring with the bondholders that pretty much allowed Argentina to take some sort of holiday, an extended one for almost 3 years, in which the interest payments were minimized and there was no principal coming due. And despite that, we see quite a retrenchment in the activities in the financial markets connected with Argentina. And this is perhaps the mirror effect of an increased cost of capital for Argentina, which reflects the uncertainty because we still have pending, I think, much more clarity in the economic policy, much more in a way that would lead people to think that Argentina has overcome its problems that reflect themselves into debt and sustainability. But debt and sustainability is a factor of different elements. It's not just the amount of debt, it's the prospects of growth, it's how the fiscal accounts would work, and how the economy somehow gets into a much more dynamism than it had before. And therefore, also, another element that is pretty common in all of the emerging markets is the vulnerabilities. And vulnerabilities, I'm particularly referring to the weakness of the local currency, the lack of demand for local currency instruments for both the public and the private sector. And with that, some increased vulnerability as well, because that reflects itself into capital outflows, capital controls that per se, when imposed, you somehow manage to reduce the outflows, but also assure yourself you don't have inflows because people see that they're getting into a trap. So overcoming that has to be part of a very comprehensive program that would include politics, economy, and dealing with all of the creditors. As was mentioned, Argentina tackled the debt with the private sector, but it still has pending the Paris Club. It still has pending some arrangement with the IMF, which is a creditor of $45 billion, a significant amount, and that would require Argentina to negotiate a program as well. So last point here, 2 points briefly. One is this is an economic problem to begin with. It has to be dealt with thinking in reducing the systemic risk and particularly allowing the private sector to tap the markets that would reinforce the dynamics of the balance of payments and reducing inflation and as well recreating prospects of growth. That's my final comment.
Okay, excellent. So, so Daniel, as chief or as finance minister and chief debt negotiator, you were involved in the 2002 restructuring, as you discussed, it just went through.
Well, it's just a brief note. The Argentine debt restructuring took place in 2005. I was not in charge there.
Okay.
Previously with the Brady deals and so on.
Okay. Well, how would you say the two compare in terms of process?
Now, I would say things, from my point of view, are to some extent a bit easier for with the some of the problems we had to tackle, and this was thanks to the imposition of collective action clauses. Anna and Lee both referred to it a bit. I think if we didn't have those, it would be much messier. It did help a lot to coordinate. We still are going through updates and refinements of those. They are far from being perfect. But the issue is also perhaps that previously we had a clear framework. There was official sector, private sector, all of them doing their job. Economic policy, everything in place was much better coordinated then than now, and that's a bit missing. It's a question of perhaps it's an issue of leadership, also understanding, and somehow coordination, which is a problem because there is nobody that really is in charge of that.
Great. Anna, Daniel, Lee, can any of you provide further color on how the landscape has changed, how this void sort of developed, and the new factors that have entered, say, in the last 20 years, including rise of China and other things that you've mentioned?
Piggyback.
Go ahead.
Sorry. Just on something that Daniel said, which is that there was a clear framework before, right? And I think that's a really important thing to realize, because much of the narrative in the sovereign debt space is that it's always been chaos, right? I think it's fair to say that it's always been soft law by and large, and then hard private law perhaps, and that public international law hasn't really been as much of a presence in this space since, at least the second half of the 20th century, arguably even earlier. But a framework had emerged where, if you asked anybody who was involved in one or two restructurings, they would tell you this is how it goes. First, the country goes to the IMF, you get the envelope for financing assurances, you get a program, you go to the Paris Club of government to government creditors. They give you a set of terms, then you go to your other creditors, the others, hop to and agree to give you comparable terms, and then you ride into the sunset and then come back in a couple of years with another crisis, right? So that's sort of the pattern of things. The trouble now is that there is so much diversity of debtors, among debtors, among creditors, among the legal instruments involved, and not as much correspondence among identity of the creditor, the legal instrument they hold, and where they might restructure this instrument. So there's an enormous opportunity for arbitrage, right? And if you look at Russia holding Ukraine's Eurobond and suing in London, it's one example. If you look at everything going on in Venezuela, that's another sort of interesting hodgepodge of interests. And I've already mentioned among low-income countries, Zambia's, Ethiopia's, Angola's of this world, So I think that this framework that might have come into existence for a fleeting moment has kind of melted and dissolved. It doesn't mean that any of the instruments that had been developed for that framework, such as CACs, right, are useless off the table. It's just you've got to realize where they work and where they're totally irrelevant. So CACs will help you with your bondholders, and the better the CACs, the better the outcome, the better the process. But CACs will not help you with China. Now, China is really interesting because it is the largest official bilateral creditor. It occupies this funny space where some of the state-owned lenders contend that they are commercial lenders. And, to the extent lending at high interest rates qualifies you as commercial, I suppose they are. But I do think there's no reason to immediately accuse them of bad faith. It's just, it's a different system. And the question is, how do we go forward in that system in the absence of the old framework? I think step one has got to be, we need to find out who's holding what, who the creditors are, what claims do they have, and then get to a collective action platform, common framework or not, that manages to coordinate these interests.
Lee, you had something to add?
Well, no, I was going to make much of the point that my friend Anna has just made. We will see in this decade a number of sovereign debt workouts where there is an astonishing diversity of creditors. It will no longer just be commercial banks or bondholders. It will include unpaid suppliers. It will include, as it does in Venezuela, investors whose investment has been expropriated and therefore who have pursued an arbitration remedy and turned final awards into judgments. It will include people who have trapped local currency in the country. And the issue is, how do you coordinate those different groups? As Anna says, collective action clauses, while enormously helpful with bondholders, we have no institutional method at this point that reaches across these different creditor groups and homogenizes them, if you want to see it that way. Iraq was probably the first country we saw that faced this problem post-Saddam. So this is Iraq 2004 and 5 and 6. In the end, Iraq settled 13,112 separate claims, ranging from a few $1,000s from people who had shipped frozen chickens and never been paid, all the way to massive contractors who had built roads and hospitals in Iraq. Venezuela, if and when it ever gets around to a restructuring, is going to be exactly the same. And the Guaido authorities in July of 2019 came out with a statement of general principles for their restructuring. And what they said was they will treat all of these claims, once reconciled, as claims against the Venezuelan state. So they will not provide preferential treatment based upon the provenance of the claim, whether it's an arbitration award or a bond or a promissory note or an unpaid supplier. But a restructuring for that country won't be possible until the political situation resolves itself. This
is a great time, I think, to bring in Andrea in the conversation. Andrea, when I introduced you, I mentioned, of course, that talking about one of the more recent developments in the sovereign debt landscape involved the use of international investment arbitration, and that you pioneered this method to enforce state debt, involved in the claims against Argentina. You've also been involved as counsel, I understand, or it's been reported at least, that there's been a claim brought with respect to Guatemala that has implication for Guatemala's debt servicing. Can you explain the role of investment arbitration and the advantage that provides to creditors with respect to sovereign debt obligations?
Sure, thank you. So, I mean, the issues that arise, or the intersection between international investment arbitration and sovereign debt, I mean, it really can arise in different contexts and at different times. There are different phases of an arbitration, and that indeed was the case in the two cases that you've mentioned. So, I mean, first, you can have situations where the creditors are using international arbitration to enforce state debt, or in the situation where essentially there's been a default and the creditors are left without recourse and they want to use international arbitration. And that was the case in the Abaclat case with the tens of thousands of Italian bondholders. There were also several other cases, also against Argentina at that same time, where the crux of the claims were that the creditors, had not been paid. Now, importantly, and I think it's important to note that the claims, the creditors in those claims, or the investors in those claims, were not arguing that the sovereign default in and of itself was a violation of the treaty. So that, of course, caused them loss, but their claims were broader than that. So they hinged on things ranging from representations that had been made by Argentina that induced their investments to also legislation that had been enacted, including legislation, for instance, that precluded Argentina from settling or making any payments to creditors outside of the exchange process, whether through judicial recourse or otherwise. So I just set that out there, that it wasn't a contractual default claim. And I think of importance for our conversation is that in the Abacla case and in the other cases against Argentina, tribunals found that the creditors who had purchased these sovereign bonds they qualified as investors under the treaty, and that their purchases of these sovereign bonds qualified as covered investments under the treaty. So that gave them standing to bring these claims. But that is really where the story ends. I mean, there are a lot of other interesting holdings that the tribunals found in those cases, but it never did reach the merits of the claims to find whether ultimately Argentina would have been liable under the treaty, and that is because those cases settled. There are, however, other cases, and I think one of interest is a case against Greece, that arose out of the insertion of a collective action clause into bonds. And there, the tribunal in that case actually dismissed the case for lack of jurisdiction. There were various reasons, and there was more than one claimant. But I think what distinguished that case from the Argentine cases is that the tribunal there found that the purchases of those sovereign bonds were not covered investments under the treaty. And one thing they looked to is the definition of investment in that treaty at issue. And while it was an open-ended definition, it didn't specifically include private debt or corporate debt. And they read into that an intention to preclude sovereign debt. And so they found that sovereign debt was, of a different nature and was not covered by the treaty. So those claimants could not recoup under the treaty. And, there are still today ongoing cases that raise these very same issues or similar issues. And I'm counsel for Peru in a case brought by Gramercy Funds, an investment fund that actually purchased agrarian reform bonds that were issued by Peru decades ago, back in the 1970s, as part of their Land Reform Act, as many Latin American countries at that time redistributed land under land reform. And at that point in time, Peru issued these agrarian reform bonds to landowners whose lands they took to redistribute. And those bonds over time became worthless because the currency had changed twice. There was hyperinflation, and many people just stopped tendering their bonds for payment. And in fact, the Agrarian Reform Bank that made payments on these bonds was actually liquidated back in, I think, 1991 or 1992. And then decades later, Gramercy went in and purchased this paper and is bringing a claim against Peru for about, over $1 billion. So that is pending. We just argued it this past year, and it'll be interesting to see how the tribunal rules, in that case. On the other side are, cases that have nothing at all to do with sovereign debt at all. But what you have at the end of the day is an unpaid arbitral award, and that was the case in TICO. And as disclosure, I'm counsel for TICO. And in that case, it's also an ICSID award. It arose out of a dispute concerning electricity distribution. And that ICSID award remained unpaid. So TICO converted that, or had that award recognized as a judgment in US court in the District of Columbia. And under the ICSID Convention, ICSID awards are entitled to be recognized as the award, a judgment of the highest court of the state. But ICSID doesn't say anything about execution. It doesn't waive the state's right to bring up immunity defenses to execution or anything else. That's up to the laws of each of the states. And so after TICO had that award converted into a judgment, it registered it in New York, and then it issued a restraining order that restrained funds that were passing through the Bank of New York that Guatemala had paid in order to make a payment, an interest payment on one of its issuances of sovereign bonds. And Guatemala, moved to lift that restraining order, but immediately after those funds were restrained, it had to alert its bondholders that payment was not going to be made timely. A few days later, or pretty soon thereafter, the rating agencies downgraded Guatemala's rating with respect to that issuance. And Guatemala had other payments, interest payments due shortly thereafter that would have been made through that same paying agent that would have been subject to restraint up until, the amount of the full judgment. And, as you know, after 30 days of non-payment, Guatemala would have entered into technical default. So before the court ruled on the restraining order, Guatemala did settle that by paying the full amount of the award plus interest, and then the restraint was lifted. So that, it's a totally different situation, but yet another instance where you see kind of the intersection between sovereign debt and arbitration when it's used, the proceeds to pay the sovereign debt are used in order to resolve a claim or to attach in order to satisfy a judgment.
Great, thank you. And this goes to the broader points that have been made by Anna, Lee, and Daniel about the sort of fragmentation of the system, the increased heterogeneity. It's yet another means for enforcing debt, adds another layer of complexity to workouts. I wonder, I don't know, it sounds like it looks like you have something to add. If not, I just want to ask, where do you think we all go from here? What lessons does the current crisis have for the future of sovereign debt? We all know, in the early 2000s, a big push for a comprehensive sovereign debt mechanism that didn't come to fruition, obviously. Is that where we think the conversation, policy discussions, and impetus are going? Is there somewhere else that it's going or should be going? I just want to open that up to all of you.
Sure, we all have a bunch to say about it. You want to call?
Why don't you start then?
All right. Well, yeah, there you go. So, if you look back at SDRM, it was sort of stunningly unambitious in its scope, right? I mean, it's a little bit like the first generation CACs that were unbelievably controversial and unbelievably modest at the same time. And then the last generation CACs, which actually, do something, kind of sailed through because the process was familiar, and really, CAC's there. We all agree it's a good thing. So I think what Andrea said is really important when it comes to Guatemala in particular, right? What you have is, several decades of capital flow liberalization and this very diverse set of claims, but ultimately the only way you can collect from a sovereign, or the best way anybody collects from a sovereign, is grabbing funds that go to another creditor. Because otherwise you have to seize ships, you have to seize, jackets, you have to seize oil in the high seas, and that's like a lot of work. So just like the bank robber, right? You go where the money is, and the trouble is that there are all of these unrelated, uncoordinated processes. So think about Venezuela. The direct investors were, I think they got an exit award or some such, and had a judgment in hand before the bondholders even accelerated, right? So that the process is very just out of whack now. SDRM strikes me as a very narrow kind of precedent that I'm not sure. So the only thing you take from it is that it's treaty based and with IMF at the center. I'm not sure that that's any more attractive today than it was in the past. A little bit like DSSI, the debt suspension initiative. All of the Sturm and Drang for 6 month, 4 year, NPV neutral postponement. I think there needs to be a somewhat more fundamental institutional rethink. And the UN and UNCTAD have certainly put forward more comprehensive, ambitious principles, but that's where the politics come in, right? So I'm not sure there would be agreement even among low and middle income countries on what debt should be covered and how the process should be structured. So the problem is bigger, but the solution is in some ways farther away. Look, if I'm a bondholder, I'm lobbying for SDRM now. I'm dying for an SDRM because, China and FDI are eating my lunch, but I'm not sure the consciousness is there.
Excuse me. Daniel, do you have any follow-up thoughts on that, on where we go from here and from your perspective?
Yeah, well, perhaps following up on what Anna just said, we all somehow were struggling to get something like SDRM in place. But in fact, it was far too ambitious, I think, given the institutional framework that we have today. I don't think I don't see anybody just being in the role of global coordinator, if you want. The IMF has certainly the ambition to do that, or had at least, but it has certainly as well some problems in they are a privileged creditor at the same time as being, well, perhaps the global coordinator would create, in my view, a clear conflict of interest. I think also UN, UNCTAD, and so on perhaps don't have the background, don't have the enforcement. The IMF doesn't have enforcement, but it has a significant carrot and stick process in place, and is pretty much in touch with the financial regulators in several countries and governments that would help. But I tend to think that nevertheless, it would help that we think of some sort of global bankruptcy, sovereign bankruptcy process, which perhaps would, in my guess, should not be that ambitious as willing to replace a court, but nevertheless provide guidelines by which everybody would abide by. And therefore, informal gatherings like the G20, where China is part of, I think could be quite helpful. And because China is a very significant player, creditor, and so on, but still, they are a significant member of the G20 as well, and are willing to play a role in the international coordination process as well. And in China, the government has much more of a say than in some other countries as well.
Lee, do you have thoughts on where we go from here? And
yeah, sovereign debt restructuring mechanism died a political death, not an intellectual death. And I don't see the politics, particularly in the United States, having changed sufficiently to warrant a rebirth, a renaissance of the SDRM. That said, there are and will be efforts to change the legal regime in a manner that encourages, let's use a charitable word, prospective holdout creditors to join a debt restructuring. You saw this in 2010 in Great Britain, where they passed a law that limited recoveries in English courts of claims against countries that had gone through the highly indebted poor country initiative, the HIPC initiative. You saw something similar in Belgium. I think there will be these efforts. But we're talking about changing domestic law as it relates to debtor-creditor rights. It's pretty heady stuff to take to state legislatures like the New York legislature. In the end, every sovereign debtor has one last resort, and that is to say that creditors that pursue their legal remedies in a manner inconsistent with the general workout process should not expect to be repaid. And indeed, the other creditors who join the restructuring will insist on it, as they did in Argentina, that if there is a preferential settlement with a non-participating creditor, it triggers a claim of everyone else for the same treatment. And so ultimately, the sovereign debtor's weapon, maybe its only real weapon, is to say that you will not find assets of ours outside of the country that you can attach. And therefore, you will go years, decades, with legal bills and nothing else to show for it. Guatemala's mistake, because collective action clauses were only one innovation. The other innovation that we introduced starting in the 1990s was the use of trust structures. The trustee is the agent of the bondholder. Payments coming into a trustee are property of the bondholders. Payments coming into a fiscal agent, which I gather was the case with the Bank of New York in Guatemala, are still the property of the debtor, and hence arguably attachable. Those countries that adopted trust structures, as Argentina did, starting in 2005, have been able to insulate themselves against that particular risk. But look, in the end of the day, what persuades any creditor to join a debt restructuring is the absence of a good alternative. The grisly saga that was Argentina from December of 2001 until the spring of 2016 showed one thing, I think. You had some of the most sophisticated, litigious, well-capitalized hedge funds in the world pursuing Argentina. For 10 years, they could not find assets of Argentina outside the country that were subject to attachment. Argentina successfully ran defenses. What brought Argentina to the table in 2016 was this theory that the pari passu clause, the equal ranking clause in the bonds, required ratable payments to all other creditors, and that forced Argentina to default even on the bonds it issued to those who accepted its restructuring. In my view, that was, when first embraced by the New York courts, a fallacy. And post the Argentine settlement, it has been disowned by the New York courts and recognized as a fallacy. So I'm not sure that weapon is there, even in the next debt restructuring. It will be escape and evasion. Sovereign debtors will have to shield their assets in a way that discourages people from deciding to pursue a path other than joining a generalized debt restructure.
Andrea, please.
And just one very, very quick note that I just want to note with respect to Guatemala, what distinguishes that case is that there was no restructuring, right? So this was not an instance where a creditor was trying to maneuver outside of a larger restructuring. I mean, Guatemala was not in distress in that regard. It has not restructured its debt. It just was choosing which creditors to pay and which ones not to pay. And it had the money to pay them all, but was just not paying, right? So it was just evading its international obligation to pay the exit award. So while that doesn't, answer your question as to whether the restraint would have held up in court, and I can't really disclose the content of the fiscal agency agreement or anything like that right now, but I think it rises in a different situation where you're not dealing with an ordinary or extraordinary restructuring.
Anna, please.
Yeah, so I think this is really important and interesting, right? Because the trouble is that all of these claims end up converging in the same place. And the value, the sort of the merits may be completely different, but then in a situation of actual distress, like Venezuela, let's say, that's indisputable, indubitable distress. It's really everybody throwing everything at the walls and seeing what sticks, and some meritorious claims and some wackadoodle claims, and everybody is basically going for the same financial flows with diverse national courts. And Lord knows, right, welcome to the common law. You can have a wacky interpretation of a pari passu clause that may die a sorry death 5 years later or 10 years later, but for 5 or 10 years it causes a whole lot of mess in the sovereign debt space. And again, same thing, you can change contracts, but then we're really in a world of just seeing what sticks. And so I think what Daniel said earlier is actually quite important, which is you can have something that looks ambitious and draws political controversy, and it actually may be politically sensible, but sort of does not practically yield results in a given crisis. It may take 20 years for, Lord knows, odious debt, it's what, 100 years later, a couple of 100 years later, we're still not sure where we are on that. So looking at fairly specific and surgical legislative solutions, and as well as, Leah's written certainly about using the UN Security Council in certain cases, I think targeting particular problems. Like, what's the problem? The problem is that a country cannot send funds from point A to point B without worrying about a random creditor intercepting those, right? What is the problem? Comparability, equity of treatment among creditors. UK taxpayers would be unhappy to see their concessions go to a Gramercy, right? That, those sorts of problems have targeted solutions that could actually be hard law solutions. I think we're a ways away from a big picture comprehensive solution.
I want to go back to something, and at this point we have only 5 minutes left, so I encourage if there's anyone in the audience with questions to put them in the chat. But I want to ask, let's go back to something Lee had said, which is, the only solution going forward, maybe for now, for states to do everything they can to keep assets outside of their borders and therefore protect them from attachment. That seems like a very and maybe completely rightfully so, like pessimistic view of where we are and where we're heading. Or and just wanted to reach out and ask Daniel, to the extent it sounds like that has cost for the state as well to put so much effort into shielding its assets and keeping them within its borders. And just ask Daniel if what you think of that sort of solution going forward. Is that the equilibrium we're sort of heading towards? And then also bring Andrea into the equation because she has experience actually searching and finding presumably some of these assets, or at least using the legal mechanisms available internationally to push states to pay up anyway.
Yeah, well, shielding assets from attachment was always a concern. I remember that's how I got to meet to meet Lee in the 80s. I was at the central bank, and we were pretty much worried with the reserves of Argentina. We just moved them to the BIS, the Federal Reserve Bank of New York, to some extent. But nevertheless, what I'm saying, it's very cumbersome and costly, because in the end, it's very difficult to restore creditworthiness while you are fending off assets. And the other problem is, very often the lawyers will tell you, well, don't worry, in the end, you will win this. The problem is what happens in between. If you get a prejudgment attachment, that's headlines in the newspapers. That creates problems with investment, flow of funds, even trade flows. And that is really very harmful to the development of the economy as a whole, and particularly very sensitive to the FX rate, which is very notable in each one of these countries.
Now, I would say on that, on really two things, because first, it is actually extraordinarily difficult to find assets that are subject to attachment, that are outside of the jurisdiction, because states often, they don't have, really state assets that are outside. They have assets that are, perhaps state entities or something like that. And then you have all of these different immunity issues and different juridical personalities. And it's very difficult to find that assets that are owned by a separate juridical entity, even if entirely state owned, that is going to be deemed to be a state asset. And then, of course, the sovereign assets themselves that are used for sovereign purposes, not commercial purposes, typically are not attachable. So, it's hard to find those. I don't think that it's, they're just all over the place. But as Daniel said, the difficulty is how different countries deal with that. Here in the United States, you have a long, long road before you get there, because you have to enforce the award first. You have to get it recognized and enforced. And that in and of itself can take years of litigation. But in other countries, you can move straight to execution before while you first filing and arguing about enforcement. And so you can get ex parte orders of attachment, right out of the gate. And that's something that, it just doesn't happen in the US, but does happen elsewhere. And then, as Daniel said, it's, perhaps little comfort to the country that ultimately you might prevail, because it can be caught up in litigation for quite a while. So those are my thoughts on that.
Sorry. We only have about half a minute left. And I'd like to invite everybody, including the panelists, to the next the follow-up to this, the continuing the conversation, to engage little bit further with some of the audience members who may have questions. We got a great question in the chat here. In a short answer, maybe we can discuss some of that more and continue the conversation. And of course, additional questions as well from the audience. But for now, thank you so much to all the panelists. Thank you to the ACEL organizers for having us, and thank you to the audience for listening. I hope you found it as interesting as I did.